Firstly, I would like to pay high respect to Venerable, respect to His Excellency, Mr. and Mrs. and all the participants who present here. Warmly welcome to our online webinar series, which is happening now. I would like to introduce myself that my name is Arbitrator, and on the behalf of the organizing committee, I would like to inform that this webinar series has been initiated by International Bachelor of Law Program since July 2020. It has been continuously supported by Sala Traju Association. That this online webinar has now become partnership between International Bachelor of Law Program and Sala Traju Association. Our webinar aims to share legal knowledge and experiences both in theory and practice to the law student and public. We have hosted 15 webinars so far, and this is the 16th webinar. The previous webinar focused on stock market, intellectual property law, law on the sea, judicial profession, including prosecution and judge, and notary professions. As wholeheartedly and numerously supported by participation of law students on previous topic, our committee has further organized other online webinar under the theme of Black and White or Shade of Gray, Resolving Dispute in International Contract, present by respect speaker Mr. Johnny Tan. Without any further delay, I would like to give the floor to Ms. Subhani Chandra, who is our moderator this morning. Please.
Thank you, Leslie, for giving me the floor. So first of all, a very good morning to ladies and gentlemen and all participants who are joining this virtual event. And also greeting to the audience who are watching Facebook Live on SIArb page right now. My name is Subhani Chandra, and I will be the moderator for today's webinar. Before take black and white or shades of gray, resolving dispute in international contracts, I'd like to first and foremost introduce our guest speaker, Mr. Johnny Tan. Mr. Johnny Tan obtained his first degree in architecture, in which he had practiced in this field for almost 30 years. He has also been a past president of the Singapore Institute of Arbitrators from 2007 to 2011. In addition, he is also an accredited adjudicator, mediator, members of Advisory Council to the National Commercial Arbitration Center, NCAC, in Cambodia. And right now, Mr. Johnny practiced his career as an independent arbitrator. Mr. Johnny is very senior in his respective field. Hence, I believe the participants are very much looking forward to the presentation. I would like to also stress that the whole webinar will be conducted for 2 hours, in which the first 1 hour and a half will be the presentation by Mr. Johnny Tan on the mentioned topic, and the remaining 30 minutes will be reserved for questions and answers from our participants. So in case you have any question, please do not hesitate to drop it in the chat box, and I will address those questions to Mr. Johnny directly in the question and answer time. And to our Facebook Live audience, if you have any question, please feel free to drop it in the comments down below, and then we will ask those questions to the speaker. There is one ground rule that I'd like to suggest the participants. Please remain muted at all times unless you are asked to ask the question to the speaker to ensure the smoothness of the webinar. So right now, without any further ado, I'd like to give the floor to Mr. Johnny Tan to deliver his presentation on the topic Black and White or Shades of Gray, Resolving Dispute in International Contracts. Mr. Johnny, the floor is yours. I think you're still unmuted. Yes.
Thank you, Chandra. And thank you, Sala Traju, for inviting me to speak to you. And I really appreciate that you're giving up your Saturday morning to listen to me. My topic today is Black and White or Shades of Gray, resolving disputes in international contracts. Allow me to share screen. Right. So my topic for you today is black and white or shades of gray, resolving disputes in international contracts. Let me start by looking at the real GDP growth forecast of 2021 for ASEAN. And you will see from the slide that Cambodia is the fourth fastest growing GDP forecast for 2021. And that's a great credit to you. I remember my first trip to Cambodia back in 2000, and I compare what I remembered in year 2000 with what Cambodia is today. It has come a long way. You have made so much progress. Your city is littered with high-rise, state-of-the-art skyscraper buildings. Your economy is thriving. Today, Cambodia has an import-export for year 2020. Your imports amounts to around about 19.17 billion. Your exports amounts to something like 17.07 billion. Total, your trade volume is about 36 billion. And this suggests that in terms of contracting parties for the production, manufacturing, logistics, distribution, there is a lot more high value contracts made between parties in Cambodia, both domestic and international. Now, Phnom Penh is now a leading international business center in ASEAN. It has a developed international business and legal community, and legal and business professionals are well placed as leaders in international businesses to maintain harmonious relationship to promote growth. So as business leaders, as legal counsels to businesses, you are well placed to advise your clients and as businesses how to promote the trade relationship and to avoid acrimonious disputes between businesses businesses in Cambodia and as well as internationally. But in all business relationships, conflicts will inevitably occur from time to time. So it's a question of how do businesses and legal advisors advise your clients how to avoid disputes. And my preference is always, this is quite ironic, being in a dispute resolution business, that I advise parties that it's far better to avoid disputes and achieve an amicable, non-adversarial resolution to preserve relationship than to adopt an adversarial dispute resolution. So my emphasis has always been dispute avoidance rather than dispute resolutions. Now the question then is, when you have a dispute and you resort to litigation, that is usually a black or white resolution. Someone is right, someone is wrong, someone wins, someone loses. But in business, is that important? Or is it more important that you preserve relationship? And very often in business conflicts, it is not always so clear-cut that one is right and the other is wrong. Very often, it is a mixture. It is shades of gray where one party is partially right, the other party is partially right, and the other. And so there is no one black and white outcome in business conflicts. It is usually shades of gray. And when there's shades of gray, is it a preferred mode to go to litigation where you have a winner and a loser, relationships get damaged, or is it far better to have alternative dispute resolution that are non-confrontational, less adversarial, and preserve that business relationship for the future? In other words, what I'm advocating is it far better to look at alternative disputes resolution where there are shades of gray? And what are these? You could have a consensual process, an inquisitorial process, and last is an adversarial process without going to the courts. Now, so my scope will cover the consensual process where we discuss approaches in negotiations, mediations, where the party reach a consensual outcome, or an inquisitorial process where you engage a third party, like to make a determination or evaluation of the matters in dispute, such as neutral evaluation, expert determination, adjudication, both statutory or contractual. I'm aware that in Cambodia, you may not have a statutory adjudication process, but we are talking about an international dispute, international contracts. And so you're not bound by what is available in Cambodia. You look across at all options that are available to you. And I will end up by sharing with you some dispute resolution clauses that you may consider when you're drafting contracts. So let's begin with litigation. Litigation is the most common cause of remedy when parties have a conflict. It is reasonably efficient, quick, and ready access. Efficient because most courts today are conscious of the time they take to process suits, and they are efficient and cost-effective because the state bears the cost for the courts. Parties, apart from paying court fees, do not pay judges' salary. It's ready because in most jurisdictions, anyone with a right to have its case present to the courts for resolution, subject, of course, to the jurisdiction of the court. But ironically, the more efficient the courts get and the more ready access are available to parties, this can ironically lead to more disputes because it is readily available. But is it the best option for the parties? Litigation is often both confrontational and adversarial. As I said earlier, you will end up with one party winning and one party losing. Is it also something that is efficient, where you're dealing with cross-border transaction? Because the jurisdiction of the courts it only extends to the territorial limits of the courts. And if you are cross-border, then unless the courts have mutual recognition of the judgments, then the parties involved would then have to relitigate their disputes in a foreign jurisdiction where the assets are available. Therefore, the question then backs today's topic is, what then are the alternatives that business partners and counsel should consider when drafting your contracts to provide for dispute resolution alternatives, particularly in the context of international trade? These are some of the alternatives available. You could have negotiation, mediation, which is sometimes referred to as conciliation, expert determination, neutral evaluation. They are almost the same with slight subtle differences. You have adjudication, arbitration, which many of you are already familiar with, and hybrids, ADR. such as ArbMed or ArbMed, which are getting popular traction with users. Now, let me start by talking about negotiation. I think I don't want to spend too much time in negotiation because all of us are familiar with negotiation in one way or another. We go to the market, we negotiate. People do not think of it as negotiation. Bargaining is a form of negotiations. And this is usually the first choice, first option available, because parties in a contract where there are differences will begin to talk to each other. And this is usually done without any third-party intermediaries. They deal directly with each other, either by way of correspondence or in a face-to-face discussion. They are often informal, unstructured, and it's left to the individual parties at trying to resolve this. And the entire approach to negotiation is that the parties want to continue their business relationship. They want to find an agreement between them that they will go with, satisfied that their concerns are addressed and that they are able to continue to work with each other. Now, and there are many types of negotiation, and if I don't want to go into negotiation because it's a topic of an entire lecture itself, but I just suffice to mention that negotiation can adopt a distributive approach, i.e. a positional negotiation, or an integrative approach, which is interest-based, right? So my preference has always been that when we negotiate, mediate, or that we adopt any of the consensual type of dispute resolution, it is better to approach it from an interest base rather than positional base. And I'll explain this later. But what I want to go into more in greater detail are the other forms of dispute resolution. And I'll start with mediation or conciliation. Oops. All right, this is a non-adversarial process. It is similar to negotiation, and usually this is entered into when negotiation between the parties are unsuccessful and has reached an impasse. Parties then approach a third party neutral, a mediator or a conciliator to help them reach a consensual outcome. Now, what is important is that parties understand that in mediation, the mediator does not decide the dispute. He is not a decision maker. He is merely a facilitator. The decisions are left in the hands of the parties themselves. And so parties retain control over the outcome of a dispute in a mediation. So what then is the role of the mediator? He facilitates the discussion. He identifies for the parties what are the critical issues that separates them. Then, understanding what issues confronting the parties, he decides an agenda. An agenda, sometimes a mediator might set his agenda as the low-hanging fruits that will help set some consensual. In other words, look at disputes that are not so far apart, where you can establish early success in the mediation progress so that you gather the momentum to deal with the more difficult issues. Sometimes, in some disputes, it might be better for the mediator to identify what are the key area of disputes that once you resolve them, the other minor disputes fall away and get resolved. And that is left to the experience of the mediator to decide how best to deal the issues in a mediation. And in doing so, he helps the party negotiate constructively by looking at alternatives and options, because a party may enter into a mediation with positions, because they look at the contract and says, the contract entitles me to this. This is what I'm entitled to. This is what I want. And therefore, that is the position I'm taking. Now, the role of the mediator as facilitator is then to say, yes, we understand that that's what you are looking for. That's the outcome you're looking for. But what is more important is to understand the interest. And by interest, I mean, what is it or why is it that outcome is important to you? The why more important than the what. Let me give you a simple illustration to explain what I mean between position and interest. Now, those of you who have families, imagine you come home one day and you have a son and you have a daughter, and there's 6 oranges in the fridge, and both of them want all 6, and they're not prepared to share. What is the most obvious outcome? You're tired from a day's work, and most obviously, a mother or father will come and say, look, why don't you just share? Each of you take 3, that's enough. And what if your children tell you, no, I want 6. 3 does not give me what I want. And how would you resolve this? In a positional mediation, you would just split the baby, so to speak, and split the oranges, 3 each. Resulting outcome is neither of your children is going to be happy because they have had to make a compromise. But if you ask them, why do you need 6 instead of 3? And let's say the son say, I need 6 because 6 is what I need to make a glass of orange juice. If you give me 3, I will only get half a glass. And then if you ask the daughter, why do you need 6? Well, I'm baking a cake. I need the pulp from the orange. And if I don't have 6 oranges for the pulp, my cake will not have the orange flavor that I require. Now that's interest. Why do they need 6 instead of 3? Then the solution becomes obvious. Give to the boy the 6 oranges. Let him squeeze the oranges. He has his glass of orange juice. The daughter can take the rest of the oranges, scoop up the pulp, make her cake, and both interests are served. And that's what I mean, that a mediator looks at on a win-win solution rather than a compromise solution. So he explores alternatives. He thinks outside the box. He looks at the interests of the party rather than the position of the parties, and tries and understand that so that he can suggest a win-win solution to them. He engages the parties and invites them to say, look, if this position is not available to you, what alternatives would you consider? What other options can you put on the table for the other party to consider? And the focus is on the commercial outcome, the interest, not the position. Right? So that's what a mediator does to ensure that he gets the best win-win outcome for both parties. And how does he do this? Usually, the parties would agree to a mediator to act as a facilitator. And he does this, they do this either by way of a contract which provides for a mediation process in the event disputes occur. Or if they do not have that, nothing precludes them from agreeing to have a mediation settlement agreement post-conflict to suggest that they appoint a mediator to act as a facilitator. Of course, it is preferred if a mediator has already been named beforehand, but very often it is not possible to do that because It's not possible to predict the kind of disputes you have and to pick the right mediator for that kind of disputes. So very often, what the parties will do is within the mediation agreement, provide for a neutral party to appoint and to select and appoint a mediator. That neutral party could be a chamber of commerce, could be a business organization that both parties accept as neutral experts within that field to appoint someone within their membership respected by both parties to act as a mediator. Once the mediator is appointed, the parties will then submit their case statements to the mediator, setting out what are the areas of disputes they have and what are the remedies they seek in the mediation. The mediator then holds a conference with the parties, initially in an open session where he invites both parties to explain the case, their respective cases, to him or her. Now, he explores that to a level when the parties reach an impasse, and then he invites them to go into private caucus where he speaks to one without the other, where he then explores options that the parties are prepared to consider, but not prepared to put on the table first. And for such private caucus to work successfully, the mediator must build confidence of the parties. He must win their confidence that they trust him, that they have faith in him, that whatever they discussed with him in private will not be shared to the opposing side without their consent. So trust building in private caucus is important because he has to establish to the parties that whatever is shared in a private caucus is going to be private and confidential and without prejudice, so that in the event mediation fails, what has been offered in mediation is a without prejudice offer that cannot be used in another forum. And he does this by sharing with the parties his own view on the merits of their respective cases, do some reality testing, which in a sense is called an evaluative process. So you'll see he transits from a facilitative process to an evaluative process. The facilitative process is where he invites options and alternatives from the parties. And if that reach an impasse, then he goes into a private caucus with each of one of them and looks at their option and alternatives and suggests to them that in his own experience, in his own assessment, there are some strength and there's some weakness in what the alternatives are. And then they could adjust their alternatives and adjust the options so that they close the gaps between the parties. And at the end of the day, if that doesn't work, he does what is called a BATNA and a WATNA process. BATNA stands for Best Alternative to a Negotiated Agreement, and WATNA is the worst alternative to a negotiated agreement. Now, so he explores with parties and said, look, if we do not reach a settlement and what is offered on the table today, are you going to be better off or worse off if you go into another forum where it is an adversarial process where you leave the decision in the hands of an arbitrator, an adjudicator, or a judge to decide? And by doing so, he tries and persuade the parties to change their position, to change their perspective on interests and understand the interests of the opposing side so as to reach a settlement agreement. Now, I find it interesting that when parties negotiate for a business deal, they do it over a meal, they do it over drinks, they do it over a game of golf. But when they have a dispute and they start negotiating, they do it at a conference table, sitting opposite each other. Most of my mediations are not held well, it is held in a conference room, but not held at a conference table. I prefer to choose a room with a round table. Psychologically, I think when people sit at opposite ends of the table, it is my side against your side. When I'm sitting at a round table, there are no sides. We're all working together to try and resolve a problem we have. I also advise parties in a mediation that it's good to have lawyers present, because your lawyers will be able to tell you the merits and strength of your case, to evaluate your case, reinforce what I say when I make an evaluative process. They are also useful that at the end of the day, when we reach a settlement agreement, to help the parties draft a settlement agreement, right? But they are not helpful if they approach it without the training and approach it purely from a positional, from a contractual perspective. Look at the contract and say, this is your right, this is where they have reached a contract, this is what you're entitled to. When a lawyer advises his client or her client in that frame of mind, my advice to them is take it to the courts. And in mediation, it is also very important for parties to understand what motivates or demotivates a settlement. I've done a mediation where we have 9 parties, and quite often you can have that. And that particular one is one where it was a condominium defects, and the claimant were the management committee of the condominium. They were looking at common area defects. They took on the developer and asked the developer to come and compensate them or to rectify the defects. The developer then says, well, if there are defects, that's not my problem. Those defects are caused by my contractor, and therefore he drags the contractor in. And the contractor says, well, not all of these defects are construction defects. Some of these defects are design defects, and therefore I want to bring in the architect and the engineers. And some of these defects are caused by my subcontractors, and he brings in his subcontractors. And both the contractors and subcontractors, some of these defects are the material suppliers' defects. And so they bring in this. At the end of the day, we had 9 different parties at the mediation. It took some effort, but with understanding their motivation, their interests, we were able to manage. We started at 10 o'clock in the morning. By about 7 o'clock in the evening, we were able to reach a settlement agreement with all the parties sharing some of the blame or some of the responsibility for the defects. And it took us another 4 to 5 hours. I think I remember we finished drafting the contract something like 3 a.m. So it's about 6 hours in the morning trying to satisfy all the 9 parties. But that's where understanding the parties' interests helped to resolve. In another case that I mediated, we went through almost, we started at 10 o'clock, so we went up to about 8 o'clock. So about 10 o'clock, 10 hours of mediating. It is a couple who's done a house, and they were not happy with the marble laid in the kitchen. And they wanted the contractor to take out the entire marble floor and replace them. You can imagine, once people have moved into the house, how difficult that would be. The damage done to the kitchen cabinets and all the others, plus moving out in that dust, all that. So what they did was, they were very adamant that it has to be wholly replaced. The contractor says, look, this marble are natural material. They cannot all be consistent because they're not manufactured in the factory. You will have different colors, you have different tones, but generally they are acceptable because that's a natural product. Now, by about 8 o'clock, it suddenly occurred to me that the husband of the couple is an eye surgeon. He does LASIK surgery and implants. And those of us who have done LASIK surgery know how expensive LASIK surgeries are and how quickly they are done. I did mine, and it took the surgeon no more than 5 minutes per eye, and I paid $6,000 for both eyes. And so like in 10 minutes, he makes $6,000. And then he follows that up with consultation. And each consultation you pay like $500 to $600, and I like 8 or 10 consultations. And if you take the number of hours in a day, I realized that he could probably have done like 10 surgery in the morning and seen 20 patients in the afternoon. With a $3,000 per patient per surgery, that's like 30,000 in the morning, and like if it's 500 for 20 patients, that's quite a substantial. He could earn something like between $40,000 to $50,000 a day. That entire kitchen floor is going to cost something like $200,000. And I thought, here, if I appeal to his interests, that if you do not settle this tonight and you go to court, you're going to spend at least 3 days in court. You're going to spend at least 2 or 3 days with your lawyers preparing witness statements. You have to engage expert witness, and it's going to cost you something like $100,000 to $200,000 before you even know what the outcome will be. On the other hand, you would have lost something like, if it's $300,000 to $400,000 a day with 6 days, you're going to lose like $200,000 to $300,000 preparing for this case. It just doesn't make commercial sense to pursue it. And suddenly you can see the eyes light up, that it's very emotional. It's no longer about commerce. And then his wife chips in. She says, the contractor has caused me so much pain in dealing with this defect and looking at my marble floor every day I walk into the kitchen. I want to make him suffer. With that word, I realized that we're not going to get a settlement, because she came in for the mediation, not to settle, but to make the contractor suffer. And she's going to take him to court just to make him suffer, even if she had spent any amount of money. And therefore, moving back to mediation, exploring the strength and weaknesses. Yes, it is expeditious. Yes, it is relatively inexpensive with minimal legal assistance required, except to take evaluative positions, evaluative exercise, advice, and to help the draft. It does preserve the relationship with the parties of the right mind. But in that particular couple, they're not likely to do a house again. So there is no relationship to preserve, and therefore it was not suitable. Confidentiality between business parties, mediation are confidential, and therefore you avoid bad publicity. And you focus on creative solutions for the mutual benefits. You are able in a mediation to explore merits and weaknesses in open environment, offer alternatives that you cannot, of a court, a judge cannot offer you, an arbitrator cannot offer you, because a judge and arbitrator decides based on the evidence, based on the contract. He cannot do trade-offs. He cannot do barter trading, which a mediator can do. And most importantly, in a mediation, the parties themselves control the outcome. They can either accept or reject the alternatives. You don't have that control in a court or an arbitration. The judge or the arbitrator decides for you. The industry standard for success rates in a mediation is about 70%. But with experience, you can achieve higher than that. My own success rate is between 85 to 90%. So these are the advantages you have in mediation. And today, I think some of you may have heard of the Singapore Convention. Signatories to the Singapore Convention much like the New York Convention, can enforce a mediation settlement in all signatory countries. So those are the advantages. But let's not kid ourselves. There are also disadvantages, and there's some weaknesses as well. For example, your success in a mediation depends on the sincerity of the parties and the willingness of the party to commit to that process. Right? And not all disputes are suitable, like in the case of the couple, where the wife are not sincere about it at all. She just wants to punish the opposing side. You're not going to get success. And if you get that, you're going to have your 30%, 20, 10, 15% failure rate. There is no complex and expensive process of discovery. It has to be done with openness, with honesty, with every intention to seek a settlement. For non-signatory countries, non-signatory to the Singapore Convention, the disadvantage, of course, is that parties can renege on the agreement after signing the arbitration agreement, or even after reaching an agreement, refuse to sign the agreement. And the only way you can enforce that cross-border, if the parties renege on the agreement or they are not signatory to the Singapore Convention, is then to sue them as a breach of an agreement. And so those are your weaknesses. Now let's move then along to neutral evaluation. Now, as I say, sometimes in a mediation, you reach a deadlock, you reach an impasse where you can't move forward anymore. Would parties be able to agree to consider neutral evaluation? Or you could even say, even before that, at an early stage, I want to consider a neutral evaluation, where I appoint an independent neutral, and he then provides us with his opinion on what are the merits of our respective case. And that opinion could be either binding or non-binding. Although that said, generally, when we use neutral evaluation, we're talking about a non-binding evaluation by the expert. In an expert determination, usually, and I say usually because it also, you could have a non-binding, usually it is binding between the parties. The processes are similar. So I'm going to deal more in detail with neutral evaluation. When we come to expert determination, we can just say, look, do a quick recap in the interest of time and just flag out that the difference between the two is a binding or non-binding. So in the process, the party appoint an independent neutral who provides a non-binding opinion on the merits. And they can do this even before mediation or when the mediation gets started. Have the neutral to look at that dispute, provide his independent evaluation, and then sends it to the parties as a non-independent, non-binding opinion for the parties to then go back and remediate where they were before. They could then see the merits of their case, the relative strength of their cases and weaknesses, and then maybe offer new alternatives and options for further negotiation and mediation. The objective is to find an amicable resolution, either at the neutral evaluation stage or going back to the mediation stage with the opinion from the neutral evaluator. But again, with all processes, there are pluses and minuses. This is useful usually when an impasse is reached in a negotiation or in a mediation, as I said, and an independent assessment may then help to break that deadlock and for the parties to go to the next level. But it can also be an obstacle. Let's say the neutral evaluator, after evaluating the case, decides that one party has a much stronger case than the other. Then that could then result in that party with a stronger case takes a very stubborn stand and say, look, I now know I've got a strong case and you don't have a weak, you don't have a strong case. And therefore, I am not going to move in my mediation. I'm going to stick to my position, and you then have to give in. It can be a stumbling block, an obstacle, but on the other hand, it could also work positively by providing the party who has a weak case but who believes it is right a reality check as to what is the likely outcome if he doesn't back off and doesn't scale down on his expectation and takes that dispute to litigation or to arbitration. He is likely to lose. And with losing, he incurs legal costs and he may have to pay costs for the other side. And so that might be a reality check for him to say, to avoid all that cost, reduce his expectation and accept whatever mediation settlement offer that is on the table. So it's a double-edged sword. How does the process works then? The process is informal, but at the same time structured. There is usually no set procedure, and it's left to the skill, discretion, and experience of the neutral evaluator, because every case is different. It takes a look at the case statements, and well, maybe I should start, go to the next slide before I explain. He obtained from the parties who appoints him a signed agreement that they would submit the dispute for him to provide a neutral evaluation opinion. And he does this by way of report. The parties would submit to him written statements of what their case is, together with any supportive documents that supports the case. Now, very often, that the neutral evaluator will then make his evaluation based on documents only. But he has discretion to invite the party to a meeting for him to better understand if he cannot understand, if the documents do not explain sufficiently the nature of the disputes. Parties can have their counsel, or they themselves can make short presentations to him. He can set time limits on how long that presentation could be. And then he establishes where they have consensus, where there are the differences, and what are the issues that are in disputes. And then he conducts a fact-finding inquisitorial process, either jointly with the parties or on his own, looking at the documents. And then he comes to a conclusion, and he provides that opinion in a written report to the parties on the relative strengths and weaknesses of the relative case. Now, if the parties agree, the neutral evaluator can also act as a mediator to help them mediate the settlement. Or, as I said, they can go back to an earlier mediator if they had a mediation earlier on. So it's flexible. They could have a mediation first, go into a neutral evaluation to get an opinion, and then go back to mediation. Or they can go into a mediation first, neutral evaluation first, find the merits of the case, and then go into mediation. It is all within the party's control. The strength, of course, is that it may help to persuade parties to resolve their cases without going to court or arbitration, and that by saving costs and time. It is voluntary. It tends to be less formal and less adversarial, because the parties are engaged in a non-confrontational fact-finding mission, rather than saying, you are wrong, I am right. So, but that must come with the right mindset, with the right psychological, mental attitude and emotion. The weakness, of course, is it is non-binding, and a party where the evaluation report is not in his favor can choose to ignore the neutral evaluator's report. And as I've said, the party who's found to be right can use that to negotiate from a position of strength. Now let's then go into expert determination. The word is not instead of evaluation, is now determination. And the word determination suggests that he makes a finding. Right? So it is similar to neutral evaluation. It's an inquisitorial process. Here, they appoint an experienced expert in the field. For example, if it is a construction dispute, appoint somebody who is an architect, an engineer, a contractor. If it's a shipping dispute, a shipping, say, a maritime accident, appoint a ship captain. If it is a ship construction building, appoint a shipbuilder. If it's an technological dispute, a dispute on technology, appoint an IT expert. So find an expert in that field with the objective of making a finding that is binding but not final. What I mean by binding and not final, you are in the midst of a ongoing contract. You want to keep that relationship, and for that contract to continue, you want to be able to say, look, let's get an interim view on this, which we agree will bind us, that we will give effect to his finding, but we reserve our right at a later date to submit that same dispute for arbitration or litigation for a final resolution. So in that sense, it is binding, but not final, because parties reserve their right to go and refer that same dispute for a final and binding resolution. So the expert then prepares a report on the issues in dispute. Based on the information and materials that's submitted to him, he conducts investigation into the dispute. He uses his own knowledge and experience to evaluate and come to a decision. And he's not bound by the rules of evidence. His role is to act as an expert, giving an expert view and conclusion, and not a judge to give a final binding decision. So his determination has temporary finality, as what I explained earlier. And if parties reserve their rights on that, they can then apply to the court or arbitration at the completion of the contract for it to be finally resolved. But very often, once a contract is over, parties have continued with that relationship. And if they want in interest of preserving the relationship, my experience found that parties quite often do not refer the same dispute to for litigation or arbitration, especially if the expert has done a thorough job of evaluating the merits. Because if he has done a good job evaluating the merits, the likelihood of it getting an opposite answer in court will be unlikely. But of course, that said, the expert does not have the benefit of cross-examination, the full gamut of time to deal with all the documents and evidence, and therefore it's rough and ready decision. Now, the process, as I said, is similar, and therefore I would only flag off those where there are differences. One of those differences is that you could give the expert a fixed time to give his determination so that you can keep moving on with your contract. He has wide discretion, similar to the neutral evaluator. He can go do inspections. He can sniff, what we call a sniff and look kind of investigation, ask for documents, look at records, look at files, look at accounts. He uses his specialist knowledge and skill to come up with this conclusion. And he either with the party's consent could become a mediator, just like the neutral evaluator could have done the same. And one other advantage is if the determination is not disputed by the parties could in their expert determination agreement says that you have a certain time by which to register your disagreement with the decision, and therefore it is binding but not final. Or if you do not register dissatisfaction within that time frame, then that decision become final and binding. So there are lots of discretion, lots of flexibility, and that's why I called it shades of gray. How do you deal with disputes and how to best manage your disputes that suits the particular kind of disputes, its complexity, its value, in the interest of saving time and cost and getting at the same time preserving the business relationship. Strengths and weaknesses are similar, so I will not go into detail with this. I will make this available to the organizers, and so that they can share this with those who are interested, and you can read them at your own time. Right? So strengths and weaknesses are the same. So let's go into adjudication. Adjudication, there are two types of adjudication. There could be statutory adjudication and there could be contractual adjudication. Examples of statutory adjudication, Security of Payment Acts, which have been introduced in many countries, Australia, New Zealand, Singapore, Malaysia, which deals with payment for contract. This particularly applies to construction work, because in construction work, payment is a lifeline to the contractor. You do not pay the contractor, he has liquidity problem, he has cash flow problems, and he will not be able to complete the works. And therefore, a lot of countries have introduced statutory adjudication for construction project for purposes of claims for payments that are disputed. Then we have the Housing Grant Generation Commission and Regeneration Act of the United Kingdom. Those are statutory adjudication, which allows any of the contracting parties to refer any dispute between them for adjudication. You could also have contractual adjudication for construction, like that found in FIDIC contracts. So statutory adjudication, one where the statute gives an aggrieved party the right to take the offending party to adjudication as long as the dispute falls within the ambit of the Act. Contractual adjudication is where the process is provided for in the underlying contract between them, that in the event of dispute occurring within the contract, during the duration of the contract, they can appoint an independent party, an adjudicator, to make a binding decision, but not final decision on them, similar to a neutral evaluation expert determination. It gives temporary finality to the dispute between them. Like the previous two, it is an inquisitorial process, somewhat adversarial, although not totally adversarial, because there is no cross-examination, there is no discovery. I'll explain the process in a while, but it is more inquisitorial rather than adversarial. And the adjudicator should be someone who has the relevant expertise in the subject matter of the dispute, so that he can use his expertise to evaluate the disputes, right? The process, how the process works is either by statute or by a contract. The parties or an appointing body appoints an adjudicator. Now, I think some of you are familiar with, those of you in construction contract will be familiar with FIDIC form of contract, where there is a dispute board appointed in the contract, right? And I'll explain dispute board separately, because that's quite a separate process from an adjudicatory process. Now, if the adjudicator is not named, then they can go to an appointing authority And they can agree beforehand in their contract who that appointing authority is, with an appointing mechanism to appoint an adjudicator. And this could be done in the course of a contract. Like if it's a dispute adjudication board, the contract would provide for the DAB to be constituted at the same time as a contract. The DAB would meet regularly, usually at quarterly. They are paid a fix on a retainer to deal with any dispute that arises along the course of the contract. And this is usually useful for large construction infrastructure type contracts, which may run for a few years. Kai Tak Airport, for instance, has a DAB, or had a DAB. Often you do power plants, or you do pipelines across long expenses, which takes a long period of time. You would appoint a DAB, and the DAB would follow the project, meets the contracting parties at quarterly, for the contracting parties to brief him or them, it could be a 3-member tribunal, a board, on the progress of the board. And then they would then have, the parties would then be able to have their dispute resolved by the board as the project goes along, so that the project keeps going. Right? The process works with the claimant giving notice of his intention to an adjudication. He submits his notice with a brief statement of matters and remedies that he was looking for. And the respondent then submits an adjudication response with a brief statement of its defense and claims and any set off. And then the adjudicator could then has a fixed time to call for a conference, peruse all the documents before him, and then files an adjudication determination, giving his findings on the dispute and his decision. And just like the previous 2 days, has temporary finality. Right? Strength, quick, cheap, competent, decision has temporary finality, is beneficial because it does not deprive of the a party for payments, which could be his lifeline. It avoids delay if it's an infrastructure project over a long period of time. It allows for the business to continue and a contract to continue without parties breaking up. And past experience found that although it is temporary finality, in the interest of preserving relationship, once the parties get paid, they get some level of justice out of the adjudication process. They are not likely to revisit that dispute subsequently in arbitration or adjudication, particularly if the party says, look, we've got this project successfully completed, maybe we could work on another project next. And if you could do that, then parties are likely to want to so one of the biggest disadvantages, of course, is rough and ready because of time constraint. It's a rough and ready justice. And if it is a contractual adjudication, then enforcement could be a problem because it would then be enforced by way of a breach of contract. But if it is a statutory adjudicatory process where the adjudicatory process is provided for by way of a statute, then the court will enforce that. Like we have in Singapore, we have what is called the Security of Payment Act, which the court will enforce and will not review the merits of an adjudication simply because a party is dissatisfied with the outcome. Right. For arbitration, and we're getting almost there. I'm mindful of the time. Arbitration is basically an adversarial process. It is an alternative to going to court. And so you may ask, why would we then go to arbitration instead of going to court? Particularly, arbitration is useful for cross-border. Cross-border because, as I said before, the jurisdiction of the court is territorial. Arbitration is non-territorial. It is cross-border. Presently, there are about 168 signatories to the New York Convention, as I last checked in June of 2021. Cambodia is a signatory to the New York Convention. And arbitration requires parties to keep the matters in arbitration, including the existing of an arbitration, confidential. Parties have autonomy. They choose the arbitrator. They choose the law governing the arbitration. And therefore, parties are able to decide for themselves how the arbitration is going to be conducted. In Cambodia, the institution that has been appointed by law as the governing institution for arbitrations, the national NCAC, the statute that that governs the arbitration is the Commercial Arbitration Law Kingdom of Cambodia, and within that law, it provides that the national NCAC, the National Commercial Arbitration Center, is the default appointing body for arbitration in Cambodia. The process is similar to litigation, with the difference is the tribunal and the parties have flexibility and the principle of party autonomy. Parties are free to decide. It's only when parties are unable to agree that the tribunal decides. It commences with a notice of arbitration, followed by the respondent's response to arbitration, and they submit that to the NCAC if the NCAC is the choice. But if it's an international arbitration, you could go to whichever center you choose, SIAC, HKIAC, or wherever, who will then appoint the tribunal. Then that will be followed by submissions of memorials or pleadings, or basically these are statement of case from the respective parties. Some limited form of discovery when you ask for documents to be produced, either in support of your case or documents that are relevant and material to the matters in dispute, followed by exchange of factual witness statements and expert reports. And then you have an evidentiary hearing where witnesses are cross-examined, oral submissions are made, and then finally an award is made by the tribunal on its decision on the law and the merits of the case. Strength, party autonomy, as I mentioned earlier, it is less formal than court proceedings. The Evidence Act does not apply in most cases. In Cambodia, it is provided in the commercial law, commercial arbitration, that Evidence Act shall not apply. You have confidentiality, which is important to businesses because you don't want the whole world to know that you have a dispute and there's somebody suing you for $30 million. You will not get another contract if all your business partners finds out about that. So confidentiality important. Speed, not always the case. Speed comes in when you have an experienced tribunal, an experienced counsel who are able to move and case manage the case efficiently. You have flexibility because parties can agree to any procedure, subject, of course, to any mandatory laws. You have finality because countries that are signatories of the New York Convention are legally bound to enforce the award unless the awards are found to be in breach of natural justice, or the arbitration agreement itself is invalid, unenforceable, or cannot be enforced, or some other breaches that are provided for in law. Otherwise, the court will enforce it and will not revisit the merits of the findings. And the greatest benefit, I think, of all is its enforceability across jurisdiction, 868 countries of the signatories of the New York Convention. So you don't have to relitigate. So if you sue somebody, say, from China or Japan or Korea, and he doesn't have assets in Cambodia, and his assets are, say, in Singapore or somewhere else, and as long as those countries are signatory countries, you can go to the court and have it enforced. And the courts will then enforce the award without reviewing the merits. So that's the strength. Weaknesses, of course, if there is no understanding of the flexibility of arbitration, counsel can have a tendency to kind of mirror court proceedings, and then that kills any flexibility, advantage of flexibility. You incur another layer of cost, and that is the cost of the center and the arbitrators. It may slow down if you appoint a popular arbitrator whose calendar is full, and you'll get difficulty trying to find dates for the evidentiary hearing. Or if, and I've always said this, an arbitration is only as good as the tribunal appointed and the counsel arguing before the tribunal. If you are incompetent or inexperienced tribunal and counsel, then the outcome may not be as desired. So those are the weaknesses. Hybrids, I mentioned hybrids. What has become very popular is where you have a met up or up met up. Basically, an met up is one where you have a mediation. And then once you reach a mediation agreement, to have that mediation agreement issued as if it was a consent award by an arbitrator, so that you overcome the problem of enforcement across jurisdiction. So another way is, which is now very popular, is the up met up. You start an arbitration, and then you apply to the tribunal to stay arbitration to allow the parties to go into mediation with a different mediator, not the same arbitrator. And then when you've reached a settlement agreement, you take that agreement back to the arbitrator to have the arbitrator issue that award as a consent award. Now, if you are not able to reach an agreement on all the disputes, at least you reach an agreement on parts of the dispute. Have that part of the dispute issued as a way of a settlement agreement, and the remaining disputes that cannot be resolved is then arbitrated on a smaller, fewer disputes, issues in dispute by the arbitrator. So there's a saving in times and costs. So let's look at some of the standard clauses. This is a mediation clause. Example, we all dispute, controversies, differences. Rising out of or in connection with this agreement shall be submitted to the name of the institution for resolution by mediation in accordance with the mediation procedure for the time of being enforced, and the parties agree to participate in the mediation in good faith and undertaking to abide by the terms of any settlement. Second sample, also on mediation, where you could say all disputes, controversies, differences rising out of or in connection with this agreement shall be submitted to the institution for resolution. Dispute, controversies, or differences shall be referred to within a certain number of days, if you want to limit those days, from the time they arose in accordance with mediation procedure for the time being enforced, unless any of the parties serve a written notice on all the other parties, and the institution stating that it does not agree to submit the matter to mediation. And the parties agree to participate in mediation in good faith and to undertake and abide by the terms of the settlement agreement. So having this, we then become a breach of an agreement if the parties do not do so. Now, example of expert determination. I want to save time for Q&A. So I'm not going to read this. I'm going to flash this, and then you can read that at your own time, and then we can take questions so that we have more time for questions. I know the time is up to 11 o'clock, right, Chandra? Yeah, I'm happy to stay. I'm happy to stay beyond that because I know that it's now left us with only about 15 minutes. But if you want to have more questions, happy to stay beyond 11 o'clock to take questions. But also, meanwhile, I'm going to flash all these different sample or clauses for you. This is one for neutral evaluation. Arbitration. This is the standard clause for the NCAC that it has on its website. And these are sample, and this one I will read because this is quite, I think, probably quite new to many in Cambodia. What we call the Arb-Met-Arb clause. Any dispute rising out of or in connection with this contract, including any question regarding the existence, validity, or termination, shall be referred and finally resolved by arbitration, administered by the Singapore International Arbitration Centre, in accordance with the arbitration rules of the Singapore International Arbitration Centre for the time being in force, which rules are deemed to be incorporated by reference in this clause. The seat of the arbitration is Singapore. The tribunal shall consist of either one or three. The language shall be, you choose the language, English, Khmer, whatever. The parties further agree that following the commencement of arbitration, they will attempt in good faith to resolve the dispute through mediation at the Singapore International Mediation Centre in accordance with the SIMC Arb-Met-Arb protocol for the time being in force. Any settlement agreement reached in the course of mediation shall be referred to the tribunal, arbitral tribunal appointed by the SIAC and be made as a consent award on agreed terms. So, conclusion, there are different shades of grey to resolve your disputes. You can adopt the consensual approach, such as negotiation and mediation. You can adopt an inquisitorial process, such as the mediation, determination, neutral evaluation, or adjudication. Or you can adopt an adversarial process similar to the court process, but with flexibility and with advantage of cross-border enforcement, such as arbitration or Arb-Met-Arb or any of the hybrid model. And on that note, thank you for your kind attention, and I'm happy to take questions.
Thank you very much, Mr. Johnny. It was such a very informative and insightful presentation to the delight of the audience. And I believe audience are having lots of questions, as I have received many as well. So right now, I'm just going to ask the first question that I received. So it's from Savanta. He asked, according to your experience in solving disputes in international contract, and as you already mentioned that there are various types of ADR. So which ADR has the most benefits to the party? And do you think what method are the most successful one? And in addition, he also asked, could you perhaps share some tips in order to draft the international contract to ensure that there is no unintentionally mistake which have been made? Yes, thank you.
I don't believe there is a best type of dispute resolution process, simply because every dispute is different. Some disputes are more suitable for mediation, some disputes are more suitable for arbitration, and therefore it's not a one-size-fits-all. You look at the dispute, you ask yourself, is this dispute complex? Is it a high-value dispute? It involves many legal issues. And then you pick the method that is most suitable for you. The bigger question, the more relevant question, I think, is a question of how do I decide what dispute resolution clause do I put in my contract before a dispute even happens, right? Because I'm in the process of negotiating a contract, I have to put in a dispute resolution clause in, and how do I then decide what is the best to suggest to my client? Now, I've alluded to this in a very indirect way. For example, if you have a infrastructure contract, construction contract, large construction contract, where you the contract runs for over 3-4 years construction period. A DAB form, like in the FIDIC form, or an adjudication agreement to submit matters to adjudication with the rights to submit matters that are not fully resolved to arbitration might be something to be considered. But then again, because the mediation and negotiation are consensual, and to some extent, even expert determination, neutral evaluation are consensual, because parties must agree to submit to that. So even if you do not have it in your contract, there is nothing to prevent the parties from agreeing post-dispute to submit those matters to a contract, to a dispute resolution process of that kind. And what you do then is that after a dispute has happened, you negotiate, and if you cannot resolve it, then the parties, with the advice of the lawyers, then say, look, we are unable to come to a conclusion on this negotiation. Perhaps we should consider one of the alternative dispute resolution process. And if we agree on that, let's draft a supplementary agreement for an expert determination, say, and then we sign off and we agree to submit that to an expert for expert determination. So it is up to the parties to decide what is the most suitable dispute resolution process for their dispute, bearing in mind the nature and the complexity and the value of the dispute.
Thank you, Mr. Chani. In addition to that, he also asked, like, what are the tips that you have to draft the international contract effectively, like without making any mistake?
Well, you want to avoid what I call pathological clauses, and these pathological clauses apply more to arbitration clauses than to the other types. The other type simply is no different from you drafting any other contractual contract between parties, because essentially they are contractual contracts. The only difference is it relates to a dispute resolution mechanism. Particular pathological clauses in relation to arbitration contracts are one where you name an arbitration institution that does not exist. For instance, let's say instead of National Arbitration Center, National Commercial Arbitration Center, you say National Arbitration Commercial Arbitration Institute of Cambodia, and there's no such body, and so your arbitration agreement cannot be implemented because there's no institute to appoint an arbitrator, or where you draft a contract where you give the jurisdiction to both the court and the arbitration. For example, you draft a contract and say, in the event of the dispute, the parties may either refer the dispute to court or to arbitration. Now you have a problem then, right? Because one party will say, well, that agreement allows me to go to the court. I choose to go to the court. And the other party says, no, but it allows me to go to arbitration. I want to go to arbitration. And so now, do you go to arbitration or do you go to court, and which forum has jurisdiction? Or where you have one that says the arbitration agreement shall be governed by the law of commercial arbitration of Cambodia. The seat shall be Singapore, but the lex arbitrae or the law governing the procedure shall be the law of Cambodia. So you have a mix and match which are not consistent, then you create a problem. So, and that's why I advocate that council need to understand arbitration when they draft arbitration agreement, because if you don't, then you will end up having problems drafting such agreement. I have a question which just popped up on my screen from Anirudh. He wants to know, could I shed some light on amiable compositor mode of arbitration and the role of arbitration change in that case? No, amiable compositor does not change the role of the arbitrator. It's basically means that parties have agreed to allow the arbitrator to decide on the principle of equity. The arbitrator is not bound by any rules of law. He decides based on what he thinks is fair and equitable. And that's what amicable compositor means, right? Whereas if you do not have that, then the arbitrator is constrained to decide the matters based on the law and the evidence. Can an arbitrator assume an amalgamated role as a mediator and arbitrator at the same time? Yes, you can, provided the arbitrator is able to consciously takes off his hat as an arbitrator and wears the hat of an mediator. And then when mediator fails, to take off the hat of the mediator and put on the hat of arbitrator without compromising his role. And what do I mean by compromising his role? Now, in mediation, for mediation to succeed, as I've mentioned, the parties must trust the arbitrator that what is shared with him in confidence is covered by the rule of confidentiality and the rule of without prejudice, right? But if he is both a mediator and arbitrator, and if you are a party in that mediation, how prepared are you going to share with the arbitrator and says, well, I'm claiming for 3 million, but I'm prepared to settle this dispute if the other party agrees to pay me 2 million. Would you be prepared to do that? Or would you say, well, hang on, if I were to tell the arbitrator, the mediator to 2 million, and if the other party does not agree, and the mediation fails and he becomes the arbitrator, how is he going to be influenced by that 2 million? Is he going to, when it comes to evaluating the value of the dispute, he's going to have in the back of his mind that I'm prepared to accept 2 million, and therefore he has been, your rights have been compromised, right? So I would always prefer where you have a different mediator and arbitrator, unless you have a person who is disciplined enough to say, look, I am prepared to put out of my mind all the things I've heard at the mediation and not take that into account when I sit as an arbitrator. And that requires discipline. Chandra, back to you.
Yes. Thank you, Mr. Johnny. So regarding that, if a participant would like to ask a question directly to Mr. Johnny, you can just raise your hand, and when you're noticed, you can just unmute yourself and ask the question directly, because there are still a number of questions as well. So if you prefer, you can just do that. Moving on to the next question I got from Piset. He asked, in resolving international contract, what are the most challenging problems that you have?
International construction project. Construction is a very complex contract. It is very documents heavy, right? Because most construction project, unless you're talking about simple domestic building of a house, if you're building a factory, you're building a high-rise office building, it's going to be done over several years. You're going to have a main contract. You're going to have between the main contractor and subcontractors, and there may be 10 different subcontractors. So you will have within that contract, that project, one main contract, 10, 12, or 15 subcontracts between the main contract subcontractors. You will have contracts between the subcontractors and his suppliers. You will have a subcontract between the main contractor and his suppliers. You will have events that's going to affect the progress of the work. So you're going to have issues of delay. Who is responsible for that delay when you have 12 to 15 parties working at the same time? So you will have to do time analysis of delay. If there is a delay, who is liable for the delay? How do I apportion that liability? Can the parties who is caused to stay longer on the site claim for prolongation costs? There may be technical issues. For example, there may be problems with geotechnical problems. It's almost impossible to find one person who is an expert in all these fields, because you're going to have structural problems, you're going to have geotechnical issues, you will have architectural issues, you will have M&E issues, you have material issues, you will have project management issues. And so you will have a wide range of issues, and that's very challenging for construction projects. And that's incidentally is how arbitration started. I started my arbitration in 1985 because the courts in Singapore at that time found dealing with construction disputes very challenging. It takes a lot of time from the courts because they are so document heavy. And the courts say, look, we think it is better that these kind of disputes are dealt with by people who are experts in the field, who understands the issues better than the courts. Because at the end of the day, for the courts to understand these technical issues, they rely on expert evidence. And so how do you persuade a court, a judge who is not technically trained in that subject matter on technical evidence? How does he decide? He decides based on the evidence presented by the expert. And sometimes an expert may be correct, but because he is not fluent in the subject, or he's not able to deliver his opinion fluently because of competence with his language, the court may be persuaded that the other expert is more persuasive than this expert. So, whereas if it's dealt with by an expert in the field, the expert will know the subject matter better.
Yes, thank you, Mr. Johnny, for the answer to the question. I think we have just another question popping up from Panirik. Panirik, would you like to unmute and ask the question directly to the speaker? Or if not, I think I can just read from this.
Okay, I yes. Can see this is a question on challenging an international award. Okay, the answer to your question is more a question of the courts, whether the courts are arbitration friendly or the courts are arbitration non-friendly. Generally, countries that are signatories of the New York Convention are bound by the convention to enforce an arbitration agreement, arbitration award, unless the arbitration agreement award is made where the parties are not legally competent to enter into the agreement, or the agreement, arbitration agreement, is invalid or cannot be implemented, where there's a breach of natural justice, where the procedure or the appointment of tribunal not in accordance with the agreement of the parties. So there are very limited scope for a challenge to an award. One of those challenges is, as what you have alluded to in your question, on a matter of public policy. Public policy is something that is a very gray area. In some countries, public policy is defined in your interpretation of what constitutes public policy. In some countries, I'm almost tempted to name the countries, but I shall refrain, given that we have such a big audience. I might be quoted and that I've named this country. Some countries are less friendly to arbitration. And so they resort to public policy as an excuse to overrule a tribunal's decision. Now, one of the things judges need to appreciate that even within the courts, right? A judge at a lower court, at a higher court, would not overrule the lower court simply because it does not agree with the findings of the lower court. There are certain rules when a higher court overturns a lower court decision, right? Where, let's say there's an error point of law, where there are gross error on the findings on fact. But if it's simply because the higher court does not agree in its opinion with the lower court, it will not overrule in general, right? So courts should look at it and say, look, just because if this was a matter I hear, I would have made a different decision. It would not be grounds for a court to say, I disagree. But some courts will try and find a way to get around that and say public policy. And I think if you read enough judgment, you will know which particular jurisdiction I'm referring to, where very often the courts have set aside a tribunal's finding on the grounds of public policy. Now, I think court should view arbitration not as competition to the courts, but as an alternative to assist the courts in managing certain type of disputes, like cross-border, like heavy technical disputes. And the court should take its role as rendering assistance to facilitate arbitration by giving assistance in the form of areas like interim injunctions, compelling witness to appear because a tribunal has no powers of subpoena, compelling parties to produce documents if the tribunal has ordered the production documents, the parties have refused to comply. So this is where the court could be helpful for arbitration. Right? So I think for arbitration to be successful in any jurisdiction, you require, I would say, 4 components that's got to work together. You need the executive, meaning the government, to introduce effective arbitration laws, to allow for arbitration. You need a strong panel of arbitrators with a strong institution to provide the arbitrators. You need the bar, meaning counsel who understands arbitration and competent in arbitration and understands that arbitration is not the same as litigation. And fourthly, you need the infrastructure, the ecosystem for all this to work together. So unless you have all four working together, any weakness in any one of these will make the success of arbitration slower in any country. And I don't want to spend too much time talking about arbitration because the topic is alternative dispute resolution, although I know that arbitration is something that is very dear to many Cambodians now because it's a new subject matter. I see a hand raised and I also see a question on the chat. Chandra, which one do you want me to take first?
I see so Papa raised their hand first. So yes, you can just unmute yourself and ask the question if you have any.
Yes, hello to professors. And my question is that what is the enforcement on in terms of properties overseas? What do you think?
Sorry,
I mean, sorry, can you hear me clearly?
I missed that word that you, can you repeat that question again?
Yeah, I just asked that what is your solutions to the enforcement of interim measures, for example, like A is Cambodian and B is Singapore, and then there's a conflict arise and they go to arbitrator to request for interim measures to retain any property in Singapore. But actually, the arbitrator, the jurisdiction is in Cambodia. So,
right.
I mean, what is your solutions to make it faster?
Okay. Interim measures, you could either go straight, if his assets are in Singapore and you want to have an interim injunction in Singapore, then I think it's faster for you to go to a Singapore court and apply for interim measure there, right? I think our court has taken a very pro-arbitration friendly approach and will hear you. You could also do it in Cambodia, have a decision on interim measure made by the Cambodian court and go to Singapore and have that endorsed by the Singapore court for the enforcement in Singapore. But what you have just done recently is, if you look at the NCAC 2021 rule, NCAC 2021 rule has introduced the concept of emergency arbitrator, where if an arbitrator has not yet worked, going back a little bit more, in the past, before the 2021 rule, if a tribunal is not constituted yet and there is urgency for interim measures, you have no choice but to go to court because there's no tribunal to make your application for interim measures. Now, NCAC has followed the rule in many jurisdictions like SIC, HKIC, where it adopted the measure for appointing an emergency arbitrator who is able to hear an interim application for interim injunction before a tribunal is constituted. He's appointed, he hears the interim application, he makes an order or an award on the interim application. And I say an award in inverted commas because award by definition deals with the substance of the merit. So an interim measure is not by definition an award, but they use the term award so that they can get it enforced under the New York Convention, right? So you can get interim measure made by an emergency arbitrator as an award and have that then filed in the court as an award under the New York Convention to have that enforced. And that would be the quickest way now that you have an EA provision in your NCAC rule.
Do you have any follow-up question, or is that it? So Pepper?
Yes, I have a follow-up questions. Like, I got the explanations from the professor, and thank you so much for the explanation. Another follow-up question is that, like, if we follow the New York conventions, we need to spend more time. I mean, spend many days to enforce the interim measures in overseas. So, what is your solution for the
Not
to make
really,
it faster? That is, yeah.
No, not really, because an emergency arbitrator has a time limit within which he must issue his decision on the application, interim application. And that is a very strict timetable. And if you go to a court, and if the court, like if you go to a Singapore court, where the courts are all, the judges are very familiar with arbitration, it would be almost administrative. You show that that's an award been made by an emergency arbitrator, and it is made without any fraud or pressure or any breach of natural justice, the court will automatically enforce it. I can't say for other jurisdiction where the courts then decide to review it and start all over again, then you will have a problem. But generally, pro-arbitration courts, you do not have such a problem.
Yes, thank you so much, Professor.
Thank you.
Thank you for the question, and Mr. Johnny, thank you for the answer. We still have some more questions. So from Anirudh Singh, he or she asked, when the parties have reached a mediated settlement, is there any significant utility for having an enforceability mechanism under the Singapore Convention?
Anirudh, I think perhaps you want to ask that question yourself, because I think it is it would benefit people to hear you.
Yes,
Anirudh,
if you're here, feel free to unmute yourself.
So the question is, if the parties, when the parties reach a mediated settlement, they can also reach it now without, using the Singapore Convention. Parties can have a settlement which has a governing law and, a dispute resolution clause. So what is the utility for having an enforceability mechanism under the Singapore Convention? Usually when parties reach a mediated settlement, they're already willing to compromise and they have already accepted the terms and conditions provided therein, because it's more or less very consensual. It's not adversarial.
Yeah.
So that's my...
Fully agree with you, Anirudh. Essentially, as my slides already highlighted, if you have sincerity between the parties and they go into a mediation with sincerity and they reach a settlement agreement, then whether you have a Singapore Convention or not doesn't really matter, because they have proceeded in good faith. But what if a party reaches an agreement, signs it today, and then comes, and very often you have an agreement where you say, well, parties have reached agreement, they would pay this amount, this payment shall be made within, say, I'm sorry, I think somebody would, you would pay within 2 weeks of the settlement agreement, right? Because you don't expect someone to carry a checkbook and make a payment of quite a substantial sum. And sometimes because of cash flow, you could have an agreement where you say the payment shall be made over 4 installment payment or periodic payment, monthly payment or quarterly payment. And what if after having done that, it decides, because for whatever reason, because of cash flow, because of a change of mind, did not pay? Having the Singapore Convention allows you to go to a court and say, look, we have an agreement. He's a member of the convention country. Just please enforce this as an agreement. Now, if you do not have a convention country, what if the party says, look, we don't pay because the agreement is an invalid agreement, or the agreement was made under, or then what you need to do is to sue the defaulting party as if this was a breach of any agreement, right? Because it's basically where you have an agreement and then you do not fulfill the terms of the agreement. You would sue him as a breach of agreement. And that means relitigating not the agreement itself, not the amount itself, but whether that agreement is a valid agreement. And that would waste a lot of time. The Singapore Convention, just like the New York Convention, allows the parties and the courts to say, look, we don't really need to re-litigate the dispute. All we need to ask is, was there an agreement? Was the agreement made? And if the agreement was made, then pay. What I normally do is this: if I were the mediator and an agreement is reached, and I would draft that agreement on the night itself, I would not allow parties to go off and then come back tomorrow and come out with new terms of the agreement. I would have them draft the agreement on the same day, sign it off before we all go home. And that's why I said earlier, I had agreement signed at 5 a.m. in the morning and 3 a.m. in the morning, because we would stay until the agreement is signed. And the agreement would normally state when that payment ought to be made. If the payments to be made over a number of payments, then I would include in the terms of agreement that if the payment is not made on the day it's due, then the entire remaining sums would be due immediately. So you can't say, look, I agree to pay over 4 times by the end of each month, and then you pay the first month, second month you do not pay and you are late. The minute you do not pay at the end of that month, the remaining amount will be due immediately. And that gives that force the parties to make sure that they pay on time.
Thank you, sir. I think these practical insights really make the case for Singapore Convention, because I have not participated in any mediation proceeding. So without these practical insights, I would not know about the applicability of the Singapore Convention. So I have a quick follow-up question in this context. You mentioned the SIAC, SIMC, ARB, Med-ARB process. So in that process, mediation would essentially utilize the enforcement mechanism provided under the NY Convention for enforceability. And the Singapore Convention removes the middleman in the form of an arbitrator. Would you agree with that?
Yes, and that's the whole purpose. You see, ARB, Med-ARB came about before we had the before we had the Singapore Convention. People are saying, well, you know, what if we have an agreement and the parties then renege on the agreement and do not pay when it's due? I would say, well, one way of overcoming this is to do the ARB-Med or ARB-Med-ARB, where whatever settlement agreement you have is then converted into an award. And once in an award, it is enforceable as any award within the 168 New York Convention countries.
Thank you, sir.
Thank you.
Hello.
Yes, sorry.
Yeah, can I ask a question?
Yes, please.
Yeah, I asked a few questions in the chat, but now I change my mind as a new question. The new question is, how do you ensure that the process of accreditations for mediators, either national mediator or independent mediator, how do you ensure that that accreditation process is really respectful and transparent?
You got to pick the right man or the right woman for the job, right? You have to pick someone the parties respect. Now, obviously, if the mediator is someone the parties do not trust, then mediation is not going to work, right? So first preference is where the two parties are able to agree on who that person is, man or woman. They agree that this person is a leader in the industry that where the disputes are involved. He's a man of integrity, a woman of integrity, honesty, and so they respect him. He understands the business, he understands the nature of the disputes, and they trust that he will facilitate and he is not going to impose his will on them. Right? Now, of course, that's ideal. Very often, one party will say, I prefer A, and the other party says, I prefer B. And I think A is your friend, and therefore I don't want A. And the other party says, well, I don't want B because B is your friend. Obviously, he's your friend, that's why you recommend him. So it's important for mediators to be neutral, to declare any conflict of interest, just like an arbitrator has to. We have in Singapore, the Singapore Mediation Center, which has a panel of mediators who are trained that where the parties cannot agree, they can go to SMC, the Singapore Mediation Center, and ask SMC to appoint somebody from their panel. Now, I know Cambodia doesn't have that. So you can either go, if parties by consent agree and says, well, we can't agree on who it would be, but we believe our Chamber of Commerce, Cambodian Chamber of Commerce, or the some other Chamber of Commerce, or if it is a government industry, say the government trade association, we respect that the president of the trade association or the Chamber of Commerce is an honest person who will appoint something suitable. You can do that. Or if you still don't want that, there's nothing to stop the parties to agree and says, we are going to go to the court with this application. Ask the court to appoint someone to mediate. We're not asking the court to hear our case. We want to mediate. We want to find our own settlement agreement, but we cannot agree who it would be. We ask the court to appoint. In Singapore, you can do that. But because we have a mediation center, they go to the mediation center. Before we had the mediation center, they sometimes go to the court and ask the court to appoint somebody. And I've been appointed by the court to mediate settlement agreement between parties. And sometimes it is the court who directs it. The court looks at a case and say, look, this is a case that we don't want to waste the court's time because this is a case that shouldn't even come to the court. It should be something that the party should be able to resolve between themselves. And the court says, well, I appoint you to go and get them to mediate and then come back to us with that mediation settlement, and only come back to us if they cannot agree. And then we will then hear the case. If they agree, then the court don't have to bother itself with that dispute.
Do you have any follow-up questions?
Yes. Follow up with that question. I think you have answered it mostly, but the other relating point is that should there be any accreditation process or institution at all to be connected to a national center or a ministry at all? Because mediation is private, it's voluntary in both agreement to mediate or to comply with the arbitration agreement. Why do we need this kind of nationally or authority related accreditations at all? Is there any good practice from Singapore?
Good question, Surya. And why do we need accreditation? I can tell you straight away that the reason why you need accreditation is that the skills required of a mediator is very different from the skills required of an arbitrator or a judge or a lawyer. Let me explain why I say that. In fact, I've sat as a mediator, co-mediate with a judge. He's a retired criminal judge. And I found that he is the worst mediator I've ever sat with, because the DNA of a judge is very different from the DNA of a commercial man. A judge is all along in his mind, somebody is right, somebody is wrong, right? Because that's the way he's trained to think. And this judge sat there and says, if you had taken your case to me in my court, you would have lost. So I suggest to you very strongly, go talk to him and settle. Because if you don't settle, you come before my court, you would have lost. And what do you think that party will do? He goes into a mediation. He refuses to move from his original position, and you will not have a settlement agreement, right? What the judge should have done is say, let's go into a private caucus. And in private, then he advised the party, look, you know, your case is weak. You should settle. You should find something to offer them that they will accept. And then talk to the other party and says, well, while you got a strong case, perhaps you want to consider lowering your expectations so that they can accept. But you keep that separate. So the process, you need accreditation 1 for the process. You need the accreditation for the method, for the kind of mindset. Mediation requires soft skill. How do you articulate something? Because a way you put something to a person could either tell the person what you think, and in which case if the person thinks that you are biased against him in favor of the other one, he will not want to listen to you anymore. So you got to frame all your statements in a very neutral fashion. Secondly, you need to be very conscious that language and body language especially plays a role, right? Listening, leaning forward, tells the other party, I'm listening to you, you are important. You have my full attention. Choice of words, cultural differences. Speak to an Asian says, yes, does not mean he agrees. His yes could mean, yes, I've heard you, but I don't agree with you. But he doesn't say that because it is rude for him to say, I disagree with you, especially if you're older. Yes, I heard you. But you go to a Western culture, when he hears yes, immediately in his mind, you've agreed with me because you said yes. Culture is important, right? So there are such soft skill training that is required of a mediator, and we accredit mediator who can display this kind of empathy to the parties. Understands the procedure, use language that emphasizes body expression language. If I were to talk to you now, and instead of looking at the camera, I'm looking here, he would say he's not interested in me, he's looking at something else, right? But if I look at you and answer your question looking at the camera, you'll say, he's listening to me, he's talking to me. So these are skills that a mediator must undergo for accreditation. Of course, you can say, we don't need accreditation. Anybody can do it. Yes, you can, by different degree of success. Okay, Soria?
Yes, I got it about the mediation skill and accreditation, how you get the credits. But my question is more about whether this accreditation process can be governed by
we've lost him.
Yeah, I think maybe because of the internet connection. Mr. Johnny, there is another question coming up in the chart. Yeah. And to Mong Chandra, would you prefer to ask him in question as well? In person as well, I mean, sorry.
Excuse me, can you just read the question to him?
Okay.
Yeah, thank you.
Yeah, go ahead, Chandra.
Okay, so
Hello. Did I miss anything? I forgot to turn off or to unmute.
Yes, you
We
were
lost your
last
connection.
at the
We didn't hear you.
moment.
So should I ask again the question or the session ended or?
Well, you can have another quick follow-up question.
Okay, I forgot to. I think I forgot to unmute now. Since you hear me, I ask again. The short question is, I understand the accreditation process in terms of skill development and requirements, but my question is about the authority. The accreditation have to be organized and governed by a government authority, or it can be only private accreditation, like by a company, or by a non-governmental organizations. How is that happening in Singapore?
It doesn't have to be government, right? It has to be, because it's consensual, it has to be something that the users would use. SMC, Singapore Mediation Center, is not a government body. It is set up by the Law Academy of Singapore. The SIMC, Singapore International Mediation Center, is a company not for profit. So you don't need government intervention to set up an accreditation body. But that said, the accreditation body must have enough gravitas within the business community and uphold a certain standard of its mediators, that parties will feel confident that they will go to that accreditation body, they will get mediators who are well-trained and capable or competent to do what they are asked to do. Because you can set any company to do an accreditation, but if you do not have that, you don't have the marketplace confidence, nobody will use you, right? So at the end of the day, it must be one where the users will have confidence to go to you, because it's consensual. Shall we take the Chandari's question?
Yes, the time will be over time, but if you are okay with that, I would like to go with Mr.
Yeah,
Chan.
I can take another like 5 or 10 minutes.
Okay. So his question is mainly about the online hearing dispute resolution, as now we're facing the pandemic. So when the intention of the party, when they draft the clause, it's of course for the physical one, but then the situation changed to online, and then one party did not agree to go with online. So like, what should we do?
Okay. There are two schools of thought. Yeah. One school of thought says, because arbitration, and I'm assuming the question is on arbitration, where because arbitration is consensual, you could say that if a party does not agree to a virtual hearing, then you should not have a virtual hearing. But that said, I also have heard that people say justice delayed is justice denied. So if you can't have a hearing, and the pandemic now has gone like 1.5 years, coming up to 2 years. And if you can't have a hearing, is justice delayed, justice denied? Then we look objectively at what is required of an arbitration. A party has a right to a hearing. And if I am able to give you a right to a hearing, is that a breach of natural justice? May or may not be so. If all things being equal, and both parties have equal access to a virtual hearing platform, equal access to internet connectivity, then there is no breach of natural justice. But what if one party is in a country where there is an extensive network of connectivity, and the other party is from a country where there's poor connectivity? And so they are equal. One can have a very smooth virtual hearing. The other one keeps dropping off and unable to connect. Is that a breach of natural justice? Then you also have to think about what is the basis of the objection to a virtual hearing. If the basis is that, well, I can't see the other witness on the other side, and I'm doubtful, I question whether that witness will be coached behind the camera, then is there a way to overcome that? Can you have 360-degree camera that can see in front and behind the witness? Can you have two cameras, one pointing at the witness, one pointing behind the witness, to make sure there's nobody else standing behind the camera coaching him? So are there ways? So first, before you make a decision whether there is a fair procedure, when one party asks for virtual hearing, the other party objects, you want to understand what is the grounds of objection, whether the grounds of objection gives rise to a perception of a breach of natural justice, where there's unequal treatment, or if all that objections can be overcome, then is there a breach of natural justice by denying the party who is asking for a hearing to not have the hearing, delay the hearing for 2 or 3 years until the pandemic is over? Now, let me give you a scenario where that could be a breach. Let's say the party who's claiming, a claimant, has not been paid, has been owed $2 million by the other party. And he says, look, I want it to be heard, even in virtual hearing, because by the time the pandemic is over, if I'm not paid, I will not be here anymore. I will be a bankrupt. And therefore, there will be a breach of natural justice to me because I've not been given opportunity to have my case heard. Whereas when there is a solution to hearing the case despite the pandemic. Now, how would you then decide? So I don't think you would make a sweeping statement that says, as long as one party objects, you should not have. Nor can you say that in every case, you must have a virtual hearing. Chandra, did that answer your question?
Thank you.
Yeah, thank you so much, Professor Johnny.
Thank you, John. Mr. Surya, I want to have another quick question. So if you are allowed, I would like to ask. Yes.
Yes, thank you. Thank you,
Yes, Surya.
Chandra. Thank you, Mr. Tan. Yes, my question is, can the court do anything when a party having signed an arbitration and a mediation agreement and settlement agreement done, however refuse to enforce, and the other party goes to the court? Can the court do anything? That one part. Another part, can the court deal with anything what is called without prejudice privilege, entitled to the mediator, which is not supposed to call upon the court to bring to be a witness?
Okay, I'll take your first question because your first question is more straightforward. Can the court do anything if a party has signed a mediation agreement and then refuse? The answer is of course, because a breach of an agreement, a settlement agreement, is a breach like any other agreement, right? You have an agreement and then you breach that agreement. It's just like having a contract and then you breach your contract. The second part of your question is something that I don't fully understand what you mean by talking about without prejudice and without that goes to the court. Are you saying
Yes.
that? Okay, go ahead.
Yeah.
Please explain your question.
Without prejudice, privilege is a theory that a principle that when a mediator or a party sign an arbitration agreement, they concede, they accord to confidentiality clause, which a party or a court cannot be, or a party or a mediator cannot be called upon to go to be a witness because they agree to keep confidentiality. How do you deal with that in Singapore?
Well, in Singapore, all mediators and the parties agree that mediators cannot be called as a witness. And so it's simply a case where if the parties goes to the court and asks the court to call a mediator to appear as a witness, the other party tells the court and says, look, you can't, because the parties have agreed that the mediator shall not be called as a witness, and therefore to call the mediator as a witness is a breach of that agreement.
And this is adopted in the legislation or part of a mediation act or just a general principle?
It's a general principle.
Okay.
Of course, with the Singapore Convention, it's embedded in the Singapore Convention. It's the same like in your Arbitration Act, right? The arbitrator has immunity and cannot be called as a witness.
Okay, thank you very much.
Thank you, Mr. Johnny. Time is really up, but we have discussed a lot about the practice and things in ADR. So, one last question. I think this will target mostly to young people like myself. So, as a senior person in this field, what are your advice to the younger people who are interested in ADR or arbitration field? Like, where do they start and how to be a very good arbitrator? Yes.
Good question, Chandra. That's always been the $24 million question. Right? Where do you start? It's a chicken and egg. Whether it is arbitration, whether it's mediation, whether it's neutral evaluation. Neutral evaluation expert determination is simpler, right? Because you are appointed because the parties consider you to be a leader in that field, an expert in that field. And so that's easier. But your question is slightly different because you say, for a younger person, how do you, you got to get unfortunately, your experience. Right? It comes with age, it comes with experience, and I don't necessarily equate age with experience. Some people gain experience a lot faster because they have been given more opportunity. Some people, even with age, don't get that experience because they don't have that exposure. So experience in terms of experts, neutral evaluations, adjudication boards and all that. Mediation and arbitration is more difficult. In Cambodia, the NCAC has, as long as you pass the exam, they accept you as an arbitrator. And so your entry route is easier in NCAC because it's so new. But if you go to SIAC and you check the SIAC website or the HKIAC website or the ICC website or LCIA websites, they will tell you that just because you have passed the exam does not automatically qualify you to be an arbitrator. They want you to produce proof that you have written 3 arbitration awards before they will accept you on their panel. And so the question has always been, how do I get my 3 awards if I don't even get on a panel first? If I don't get on the panel, I won't even be writing 1 award. And if I don't get that award, I don't get on your panel, and I don't get your panel, I can't produce 3 awards. So it is chicken comes first or the egg comes first. And this has been a question all along, you know. My advice to my trainees who have gone through this and say, Johnny, I've gone through this training. How do I get my first case? Now, if you're trying to get your first case through established centers and institutions, it's going to be tough because they want to preserve their standard. And in order to preserve the standard, they don't want to be the one to take you in and let you do by trial and error and show that you can do it. So they want you to do that somewhere else. And once you show them that you've done it somewhere else, and then you show them that you've written an award and they look at the quality of your award, they think, fine, I will put you in. But for Cambodians, I think how to get in? NCAC. Pass the exams, subject to certain requirements. I think there's a certain requirement that requires you to have certain personal characteristic. They check with your background, with the criminal background, insolvency background. They do a check on that, and everything is clear. You get admitted, even though you've never written an award before. I'm not going to comment whether that's right or wrong, but I appreciate that it is a new institution, and therefore, if it insists the same standard as established institutions insist, then you will have a center with no arbitrators. So you have an arbitrator, and you accept that this is a work in progress, and you try to improve the standard as you go along. But then as long as everybody understands that, that's fine. So in my view, I think for domestic cases, that's fine. But when you have international cases, it may not be so clear-cut because the expectation of an international client with international lawyers would be very different from purely domestic.
Thank you, Mr. Johnny, for giving the advice to the fellow younger people who are interested in the arbitration field or ADR field in general. I think we really ran out of time, and it's 20 minutes past the set date. So thank you very much, Mr. Johnny, for the insightful presentation, and as well as for your flexibility in taking all the questions that have been asked by the audience. And I'd like to thank the audience as well for being a very engaging audience to make this webinar. It's 2.5 hours, but it just feel like a very short time. So in any case, I hope you all have learned and enjoyed this presentation as much as I do. And for the time being, I would like to give the floor back to the organizing committee representative, and our Q&A session has come to an end. Thank you very much.
Thank you very much.
Due to time constraint, I would like to apologize for any mistake occurs during the webinar today. Again, we would like to express profound appreciation to our speaker today for having present a very informative presentation and discussion, and also share knowledge, experience, and wisdom to our participants this morning. Next, I would like to say special thanks to our moderator for making this webinar process smoothly. Finally, I would like to say thanks to our participants for spending precious time to listen and questions during the webinar this morning. I hope you have gained some new knowledge in regard of this webinar. Before we end this webinar, I would like to request everyone here to open the camera to take picture as souvenir with our speaker. So, ready? 1, 2, 3. 1, 2, 3. 1, 2, 3. Thank you so much. So our webinar has come to an end. I wish you all well, luck, and don't forget the prevention provided by Ministry of Health, 3 do and 3 don't. Thank you so much and goodbye.